Good afternoon, everyone. This is Ray Hickson. I want to say welcome to today's webinar. As most of you probably know, I'm with the law firm Hickson Agatani, LLP, and I'm here today with my co-presenter and my partner, Brian Agatani. And our topic today is severance agreements legal update. For those of you who are not familiar with Hickson Agatani, just a few words about us. We are a boutique employment law firm with an office in San Jose, California, and I split my time as well in San Francisco. We provide proactive advice to employers on legal compliance, including with regard to the topics we will discuss today. We also defend employers in employment law litigation. And Brian and I have worked together all the way back since the year 2000. Our other partner is Mary Wang, who we've worked with since 2004. And ever since 2008, we've been here at Hickson Agatani. Before I get into the substance of the program today, just a few technical notes. One on audio, we do recommend if you're having trouble to hear us and you're trying to listen through built-in computer speakers, we would recommend to try to use headphones. That is often a good solution for audio, or there's another audio option to dial in by telephone. Materials, at about 11:20-ish, we sent out an email with the handouts, and also you can access the handouts through the handouts icon, and go to webinar. Q&A, we love taking your questions and would ask that you, as soon as you think of a question, by all means, go ahead and type it into the questions field. And then we're going to stop in the middle of the program and answer as many questions as we can, over here over the audio. We'll also be typing in answers to questions the best we can. We have almost 1,000 people registered today, so we may not be able to answer every question, but we'll do our best. And then at the end of the program, we'll also be answering some questions live, and we'll continue to try to type in answers the best we can. So with that, let me give you an overview of our topics for today. Let's start off with, well, what is a severance agreement? Just to make sure that we're talking the same language as we get into more technical information. And then we'll turn to the breaking news with regard to severance agreements, which is this ruling by the National Labor Relations Board in McLaren Macomb that invalidated and said it was unlawful for an employer even to offer what for a long time have been considered standard non-disparagement clauses and standard confidentiality clauses. Then we'll just take the opportunity, since we are talking about severance agreements, to review some general do's and don'ts for severance agreements. And Brian is going to review specific, detailed federal law requirements for employee severance agreements, and also state law requirements, including under California law and some select other state requirements outside of California, because we know our clients now have employees all over the place, working remotely in particular. So you do need to, try to, keep abreast of laws outside of California as well. With that, let's talk about, well, what is a severance agreement? So we were talking the same language here. It's a written agreement that an employer can offer to a terminated employee, and it would provide some sort of severance benefit. A severance benefit is almost always some number of weeks or months of base salary that the person would receive if they sign the agreement. The severance benefit often includes COBRA reimbursement to reimburse them for some, let's say, equivalent period of time, equivalent to the base salary time period, to reimburse them for continuing health insurance under COBRA. Sometimes the severance benefit may include some outplacement assistance, let's say from a firm like Lee Hecht Harrison, which you've probably heard of, which is one of the leaders in that field. They did not pay me to say that, but I'm just giving you an example. But some outplacement assistance, that's more common I see in layoffs where a severance agreement is offered, but less common in other situations. Now, it would be very important for the severance agreement that it really needs to include a waiver of claims. That's what we're paying for. We're paying to get closure. That's why we're providing the severance benefit. So we would definitely want them to release all legal claims against the company. There are other standard terms. I'm going to save that topic for a little bit later when I get into my general do's and don'ts. I should emphasize that California and federal laws do not require severance for at-will employees. I mean, that's part of the essence of at-will employment, is either party can terminate the relationship for any reason without any strings attached. So In some rare cases, high-level employees may negotiate employment agreements that include severance clauses. And so that may just be what you need to do for negotiation purposes to bring in that top talent. But we definitely don't recommend having severance clauses in your, let's say, usual offer letter that you provide to most of your employees. What about this? What types of terminations warrant offering severance? So I thought it might be interesting to run a poll on this that we can use to center our discussion around. And you will be able to see through this poll some market trends. Most of our clients are in California. We do represent an awful lot of tech startups. So the results of this poll could be tilted somewhat towards the tech startup industry. But let's see what you say here. I see you're voting as we speak. So the first option, and you can vote for, of course, multiple options in this poll. Does your company generally offer severance with layoffs? Does your company generally offer severance when, let's say, you've made a hiring mistake, I might call it, as the second option, that we hired somebody and they didn't end up having the skill set we were looking for? And a lot of times companies have, and we do recommend companies consider having this, an introductory period in their offer letters that just makes really clear, no surprises. Let's both of us size up in the first 90 days whether this is a good fit. And a lot of times things don't work out, and so you part ways, and you may offer severance there. Performance-based terminations, do you generally offer severance there? Misconduct-based terminations and voluntary resignations. Okay, so we've got about 64% have voted, and I'll just leave this open for a few more seconds, and then I'll go ahead and close it out. All right, let me just go ahead and close this out. About 2/3 of you have voted. I'll share the results. All right. The results should be coming on the screen. There we go. 92% of your companies generally offer severance for layoffs. That's not surprising. I mean, historically, traditionally, severance is for terminations without cause, and a layoff is a classic example of a termination without cause. So this is what I would have expected. 17% say you're offering severance generally when, let's say, we've made a hiring mistake and we realize we hired the wrong person, and so we're letting them go. So I'm surprised that one's not a little bit higher, actually. I actually do think that this could be an appropriate situation to offer severance, and not that you have to, but we might not look at this as a termination for cause where there was just a disconnect about this person's skill set. In most cases like this, we would not have put them on a performance improvement plan or gone through formal performance counseling because we realize they just don't have the skill set. So you could, in my opinion, at least justify offering severance in that situation if you wanted to. Performance-based terminations, 48%. I would say that's not too surprising because I do think this audience is tilted a bit towards the tech startup community. I think if we did a poll of that was proportional to all employers, the number would be a bit lower because ideally when we're doing a performance-based termination, they have received performance counseling, they've been put on notice and continue to fail. That would be considered a termination for cause. So it's not necessarily expected that with a performance-based termination that they would be offered severance. But in my opinion, it is a good idea to consider doing that on a case-by-case basis. You may have a situation where there are special risk factors present, or maybe where the manager didn't do a very good job on the performance counseling, and so you can justify maybe making an exception and offering severance in that kind of a situation. Misconduct-based terminations, I mean, in my opinion, frankly, that should be 0% that we're offering severance in that, because, I mean, just think of how that's come up in the Me Too movement, for example, of how bad it looks when there's been, people guilty of sexual harassment rewarded with severance when they're being fired. So, I mean, that's obviously an extreme case that looks pretty bad, but generally speaking, I would avoid offering severance with misconduct-based terminations, but I realize, yeah, there are special circumstances here and there where that might be a good decision. I guess I'll mention this as well. One option would be to well, don't offer any severance right off the bat, right? Because that could actually undermine your case if it looks like if you're saying you've got misconduct to fire them over, but then you're offering them severance, that could actually end up maybe making your case look weak if they don't sign the release and you end up in litigation. It could actually be used against you. So one option would be to terminate them without severance and then wait and see if they demand something. If they do and you get into negotiations, one benefit of that is those negotiations are generally not admissible against you in the course of litigation, because the evidence rules want to kind of promote negotiations, but for it to work that way, you would have to wait for them to demand something. Another benefit of waiting for them to demand something is you're negotiating from zero instead of negotiating from a higher floor, which may be your standard severance offer that you make right off the bat. So it could be a beneficial dynamic for negotiations. Only 5% of you say you generally offer severance and voluntary resignation. So, I'm not surprised that it's 95% of y'all don't. And to be honest with you, if those 5% were any of them were my clients, I would definitely want to talk with them about that, because why are we offering severance and voluntary resignations? So, because if we're doing that, it would seem like we're going to offer it to literally anyone. And if somebody's resigning from the company, that is a very low legal risk, right? They haven't been terminated, obviously. So they voluntarily chose to leave. So thanks for participating in that poll. I think the results are good to know kind of what the trends are out there. And let's get back into the slides. So now we're going to turn right to the hot topic, the breaking news from February 21 of 2023 this year. McLaren Macomb, this is a ruling by the National Labor Relations Board, NLRB. And they ruled that it was unlawful for the employer even to offer employees a severance agreement that included a standard non-disparagement clause and a standard confidentiality clause. What was the non-disparagement clause? Well, it's a very typical looking clause, which I've quoted here on the screen, that the employee, in exchange for receiving the severance, part of what they agreed to do is to not make statements about the company or the employees to the public, or to employees that would disparage the image of the employer, its parent, affiliated entities, officers, directors, employees, agents, representatives. So a pretty typical looking clause there said it was unlawful. Why did they do that? So, excuse me. The NLRB said that this provision on its face interferes with Section 7 of the NLRA, which that's something that as employment lawyers we think about often and see cases dealing with this often, about protected employee speech rights. So the NLRA does say that employees have a protected speech right to engage in the most focused on aspect of this law is called concerted activities. And that's kind of a fancy word, but what does it mean? It basically means that somebody's saying something that has to do with working conditions for employees or terms of employment for employees. And there have been cases where, things are happening on social media and some employees trashing the company or what it's doing. And if there's some connection to employee working conditions, then that is actually protected speech. So they're allowed to do that. So what the NLRB is saying is, these non-disparagement clauses are unlawful because they conflict with these employee free speech rights. Now, the NLRB did say that there's some exception here, that there is some speech that is so extreme that it is not protected by the NLRA Section 7. So that's in the second to the last bullet here on my slide, is that if the speech is so disloyal or maliciously untrue that it loses the Act's protection. So maliciously untrue, that's easy to kind of get our arms around because we know what defamation is, right? So that's essentially what they're talking about there. Disloyal is one that's a little bit harder to interpret or takes a little bit more work to interpret. So if we look at what the rulings have said about what counts as disloyal, well, to break that down a little bit more clearly, they're saying that's maliciously motivated speech intended to harm and unrelated to terms or conditions of employment or any ongoing labor dispute. So the fact that it is not related basically to working conditions and that it's intended to harm the company for malicious motive, that's that's really what they mean by disloyal. All right. On top of finding the non-disparagement clause unlawful, the NLRB also found a standard confidentiality clause to be unlawful, where basically, and this again, it's very standard language that we've seen for decades in these agreements, that the employee agrees to keep the terms of the agreement confidential, other than they could be disclosed to a spouse or professional advisors for legal or tax advice. So I know all of y'all, just like me, you've seen this kind of language in agreements for years, seems like since the beginning of time, and now they're saying that's against the law. So what was the rationale for this? The NLRB said that this also violated Section 7 employee free speech rights, because it would end up prohibiting them from discussing with each other what they may think are unlawful provisions in a severance agreement, and it would end up prohibiting employees from working together collectively to try to do something about it. So now we have one update. This update actually came out since we even sent out the invitation for this webinar, that the General Counsel of the NLRB issued a memo, which we are providing as an attachment A, which clarifies this and actually clarifies a few other things that we'll talk about. But on this one, the NLRB General Counsel clarified that the NLRB's position is that these confidentiality clauses can still prohibit disclosure of the financial terms of the agreement. So the severance benefits, as we talked about earlier. So now, instead of the confidentiality clause saying that all of the terms of the agreement are confidential, we can't do that, but we can say that the financial terms are confidential. What else did this General Counsel memo say from the NLRB General Counsel? That was published again. It was published March 22, 2023, just not like a week ago. So a few other things that clarified that I think you might be interested to hear about. One, they said specifically the surrounding circumstances do not affect McLaren. So McLaren, this ruling applies in every situation. So that could be, you're in litigation. That could be that the employee is asking you for a non-disparagement clause, or the employee is asking you for a more broad confidentiality clause. NLRB is saying it does not matter. The NLRB is also saying it doesn't matter what type of agreement. So you couldn't put this kind of stuff in an employment agreement. You couldn't put it in your employee handbook policies, and you can't put it in an email communication. You can't impose non-disparagement or this kind of confidentiality requirement in any context, not just a severance agreement. The NLRB General Counsel also reiterated that it's unlawful even merely to offer an agreement with these clauses, even if the employee doesn't sign it. They're saying you violated the law by even offering it. The General Counsel said that McLaren applies retroactively. Isn't that interesting? These clauses that we've, that are very customary and traditional for many years, suddenly it's not only against the law now, but it's always been against the law according to them. So they did note that there's a 6-month statute of limitations. So if 6 months have gone by, then you shouldn't have an unfair labor practices charge because it's beyond the statute of limitations. I will say this: if they tried to go after every company that had these clauses in their agreements, they don't have the capacity, right? So it's just happening so many times on a daily basis that I don't think there's a practical risk of you getting unfair labor practice charges, or it's extremely unlikely for what's happened, let's say, in the past 6 months. So the NLRB did also say that normally they would only seek to void the unlawful parts of the agreement. So they wouldn't generally they wouldn't try to blow up the whole severance agreement like the release, right? But just to make sure that these unlawful clauses are no longer in effect. I should caution, though, that California courts could take a different approach in a particular case because they're not the NLRB. So a California court, they make clear that it's in the discretion of the court as to whether to what they call blue pencil an agreement that has unlawful provisions in it. So the California court could, in its discretion, try to save the agreement and just strike out the unlawful parts, or it could say we're just torching this whole agreement, including the release. What would the court consider in that kind of a decision? Well, the courts emphasize that if they're doing you a favor if they do this, and it's part of what they call their equitable power. So it needs to be all about equity. So if it is a situation where we didn't know how the NLRB was going to rule on this, and we just had these two problems with our agreement, we didn't, we honestly didn't know any better, I think a very strong chance the court would not torch the whole agreement. But what if your agreement not only has these problems, but has several other problems in it, several other kinds of unlawful language? In that kind of a case, the court is probably going to be more likely to just torch the whole agreement. It makes me think of one case I recall where there was an agreement that had an unlawful non-competition clause in it. And this is a well-known aspect of California law, that non-competition agreements are unlawful in California, and it's been held to be part of the fundamental public policy of the state. And the court, it refused to blue pencil that out because it was frankly offended that an employer would even try to do that when the law on this is so well established. So they said, sorry, you're not coming to us with clean hands, so to speak, and so we're not going to do you a favor to just blue pencil out that illegal part. We are throwing out the whole agreement. So we don't want to be in that situation. Now, one very important exception to this McLaren ruling: it does not apply to supervisors. So what is a supervisor? The NLRA definition of a supervisor, I've listed it here. This is very similar actually to the definition in California for who has to be trained as a supervisor on prevention of sexual harassment. And it basically goes all the way down to the level of somebody who can even, let's say, direct the work of other employees. So they might not even be in, quote, management. Maybe it's somebody who's a lead. Under this definition, somebody who's a lead, they're not really in management, but they're able to direct other people's work. It would seem they would qualify for this just as they would have to be trained as a supervisor for purposes of sexual harassment prevention. I want to really highlight that this definition is distinct from the overtime exemptions. So it's distinct from the administrative exemption, which is not even a supervisory exemption. Also distinct from the executive exemption. Now that is a supervisory exemption where somebody has to supervise 2 or more full-time employees or equivalent, and also has to be responsible for managing a recognized group or department of the company. And there's other requirements as well. But the executive exemption, you could say, is more narrow than this NLRA definition of a supervisor. And the professional exemption, like a computer software professional, electrical engineer, some kind of professional, well, they don't have to be. That's not a supervisory exemption either. So in any case, I just want to highlight the difference here. So what do we do? What do we do about this? That says, okay, this is kind of good news that this does not apply to supervisors. So the recommendation would be that we, and this is your judgment call as employers, but you can have, if you want, different severance agreement forms for supervisors versus non-supervisors, because you don't have to worry about this McLaren stuff with the supervisor. So with a non-supervisor, what you could do is, or what I would recommend that you do, is work with your legal counsel to narrow your clause in your severance agreement so that it's consistent with McLaren, which is basically meaning it's only saying the financial terms are confidential. What about the non-disparagement clause? I think you've got 2 options here. You could work with your legal counsel to narrow the non-disparagement clause so that it's only applicable to the types of speech that McLaren and the NLRB General Counsel have said are not protected. And in essence, that's things that are maliciously untrue or with the malicious motive, as we discussed in an earlier slide. I should provide a caution here that McLaren was not explicit about what kind of non-disparagement clause would still be okay. So I'm kind of reading some tea leaves here to some extent. They didn't come out and say, if you word it this way, it's going to be fine. So there's some degree of risk with this or some degree of uncertainty. So option 2 would be, if you just don't want to take that kind of a risk And if your company isn't really worried about whether your non-supervisors are disparaging you, you could just take it out, right? And then you have that comfort of knowing you have basically zero risk on this one because you don't even have a non-disparagement clause. If it's worth it to you to take a bit of risk, then again, option one, work with your counsel to come up with a more narrow non-disparagement clause. All right, what about supervisors? The recommendation would be option one, you can have a separate form of separation agreement between, from supervisors instead of the one you're using for non-supervisors, where you do retain for supervisors standard confidentiality and standard non-disparagement clauses. I do still recommend, if you haven't done this, to have your legal counsel review your severance agreements, because you can see here, these are highly regulated kinds of agreements, and when we pay somebody severance benefits to get a release, we want that to hold, right? We want that to give us real closure, and so you don't want to mess around with having something that you're using in that situation that hasn't been blessed by your legal counsel. Option two, you could just use the same form you're using for non-supervisors. So if it's not worth it to you to have a separate form, and you're not that concerned about, disparagement, and you're not that concerned about keeping the financial terms, or I'm sorry, if you're not that concerned about information apart from the financial terms being confidential, you could just say it's not worth it to us for this complexity of having two separate forms, and just have use the non-supervisor form for everyone. Okay, so that gets us through McLaren, and now I just want to run through some general recommendations on severance agreements, just general recommendations. First off, what are recommended provisions? Well, we want to confirm what their separation date was. We want there to be an acknowledgement that they've received their final paycheck, that they're agreeing they've been paid everything that they are owed. And by the way, you can use this as a checklist looking at your forms to see, do you have all these things in your agreements? We want something to confirm they've returned all company property. Also, a reminder about their confidential information obligations. And this is a bit different one than the confidentiality of the agreement. This is talking about company trade secrets and proprietary information, that they're reminded of their obligations, not to misappropriate that kind of information. There obviously needs to be a waiver of claims, including reference to California Civil Code Section 1542, which Brian is going to talk about. Non-disparagement clause, but make sure it's a legal one in light of the McLaren case. Attorney's fees, that if they breach the agreement, let's say by suing you, you should be able to get attorney's fees. Confidentiality, but tailored to comply with the McLaren case. Some language that this is the entire agreement. There's no verbal agreements, and it can't be modified except in writing. That's standard contract language. And some language about review of the agreement, which Brian's going to talk about how much time did they get to consider the agreement and to consult with counsel. Brian's going to talk about that. Other recommendations, and this is kind of teeing up what Brian's going to talk about, but you really do need to have different versions of separate severance agreements for different situations. As Brian is going to discuss, you need different versions for employees age 40 plus versus under age 40. You need different forms of severance agreement for an individual, let's say one-off termination, as compared to a group termination, i.e. a layoff. Brian will talk about that. You need state-specific severance agreements because it's the law of the state where the employee works, wherever they're working, that governs their employment. And now, at least you should consider having, I think, separate severance agreements forms for supervisors versus non-supervisors. Another recommendation is this. If you've got a situation where you're letting somebody go and they're not already represented by legal counsel, don't use some kind of don't use what I will call maybe an overkill looking kind of agreement. That's going to scare them and intimidate them into going and thinking that they need to get legal counsel. So what do we do with this? So we've got two different forms of severance agreement. One of them is just in your standard termination, right? There's no lawyers around, and you just want something, kind of quick and easy. So the other kind of situation, we have a different kind of form. Let's say we're in litigation, or there are legal demand letters. Okay, in that case, there's no reason not to use the full-blown, form that might seem a little overkill with all the bells and whistles because everybody's already lawyered up. But I would say don't do that in a case where you just want to have something quick and easy. Maybe I'll just put on my screen real quick. And this form we have not provided because we think you should get your severance agreements from your own legal counsel, but I just want to kind of give you the look and feel. This is our form that we use for, the situation where we think the client should just try to get something quick and easy. You can see this doesn't have a lot of scary looking legal disclaimers at the top of it, and it's basically just drafted as a letter. I appreciate the time you spent speaking with us about the terms of your separation from the company. It's got all the essential things in it, and it's less than 4 pages, like 3.5 pages long. You can probably sense how this type of a form is much less likely to maybe scare someone to death if they really have to get a lawyer. But compare this. What if it was 10 or 12 pages? What if you have lots of stuff in all caps and you've got everything but the kitchen sink in here? You can understand why that's more likely to make somebody think they need to go get a lawyer. And of course, once an employee gets a lawyer involved, they want their money too, and things are going to get more complicated. Anyway, so I at least wanted to highlight this as something to think about. Are you using an overkill severance agreement form for your everyday routine separations? If so, you might want to rethink that and maybe see if you can get a more streamlined looking form for that kind of a situation where really you can have something that's good enough that's more simple and straightforward and maybe more effective for your goals. Okay. Well, let me just get my slides back here. All right. I might just nitpick a couple of things. Sometimes my quick and easy kind of form does not have an arbitration agreement in it, and it's a good example of something that I think is overkill. I mean, if we're getting a release from the employee, why in the world do we think we need to have a page in there about we're going to arbitrate any claims, right? Okay, yeah, if I'm paranoid, I could think of some scenario where maybe just some kind of arbitration will come out of it, but it's extremely unlikely. I don't think it's worth the page taking that up in the agreement. Covenant not to sue. This is another one that I tend to advise against because a lot of times covenants not to sue get attacked as being unlawful because they're interpreted as the employee can't go to the government to report some kind of legal issue, which we can't really do. And a covenant not to sue is really a belt and suspenders thing that most of them I don't think that you need because what we already have is a waiver of claims. We have a waiver of claims. So what would a covenant not to sue add? Well, I really think the only thing it adds is that, well, if they break that, maybe you have a stronger case to get attorney's fees from them. But, these are not, your employees are normally not deep pockets. And the chance that you're actually going to sue them and get attorney's fees for breaking the severance agreement, I've never seen that happen personally in my 28 years of practice. So those are just two examples of things that I kind of question the need for when we want a simple and straightforward separation. Okay. A few common mistakes here to run through that we see with severance agreements. One would be providing an employee with a severance agreement to sign before their last day of employment. The problem with that is that a severance agreement, the release does not apply to anything that happens after it's signed. So under California law, there's a risk that they could still sue for wrongful termination if they sign it before their last day. Another problem is if you're saying they need to sign a severance agreement, let's say to keep working through a transition period, that's actually in direct violation of current California law under Senate Bill 1300, which says we cannot require somebody to sign a release as a condition of employment or continued employment or a bonus for that matter. So we don't want to do that. Now what we can do, and we provided you a form for this, which is attachment C. What we recommend doing is if you want to have somebody stay around for a little while after you tell them they're being terminated, which is not the conventional wisdom, of course. The conventional wisdom is we walk somebody out right away. But if you do want to offer a transition period to them, then you can use a form letter such as the one that we've given you as attachment C. And that form letter says, unless they engage in misconduct or fail to return company property, basically, we are intending to offer them a severance agreement on their last day. So we don't ask them to sign it before their last day. Now, you can attach a draft if you want of the severance agreement for them to review, but we don't want them to have it and sign it before their last day. All right. Another common mistake, requiring an employee to sign a release as a condition to receiving payment of earned wages, like their accrued vacation, accrued PTO, bonuses, commissions. So we can't do that. There's actually a California Labor Code, section 206.5, that says it's actually a crime. It's actually a crime. I can't go to one of my employees and say, if you want to get paid, you have to release your legal rights. It's actually a crime. So we cannot do that, whether it's vacation, a bonus, a commission, salary, anything else. So we have to pay all earned wages unconditionally. Now, if there's a bona fide dispute as to some part of the wages, let's say, yeah, we concede we owe you a $10,000 bonus, let's say, and you go ahead and pay that. The extra $5,000 you're asking for, we don't know about that. We think we have a good defense against that. Well, for the part where you have a bona fide dispute, that could be subject to negotiation and a release. Another common mistake is assuming that severance pay is an offset against WARN liability. WARN liability is for the 60 days notice you would have to provide before a mass layoff. So this 60 days pay and benefits under WARN has to be unconditional, which means you can't require a release for that. So if you have a WARN layoff and you want a severance agreement, that means you're going to have to offer something more. All right. Common mistakes, a few more here. To have non-waivable claims in the release. So there's just certain things that can't be waived. And this is one where you just have to make sure your lawyer vets your waiver to make sure it doesn't have any of those things in it. Also, having a restrictive covenant in the severance agreement, like a non-compete, customer non-solicitation clause. And now even some courts are saying employee non-solicitation clauses are unlawful. That's a mistake. So this is not, this is the last place, well, you don't ever want to ask anybody to sign something that's not legal, but especially in the severance agreement, where we don't want the agreement to be blown up because we want that release. All right. Another common mistake, using a severance agreement as a substitute for proper performance management. That's pretty risky. If we have a situation where, some employee thinks they're doing fine, and you surprise them with, would you like to leave and sign the severance agreement? We have a saying in employment law, the greater the surprise, the greater the risk. So, and that's because they could think, well, why is this happening? They must have some ulterior motive, discrimination, retaliation, what have you. So we would advise against approaching somebody with a severance agreement until you are prepared to terminate. And being prepared to terminate should mean it's not going to be an out of the blue complete shock to that employee. Last common mistake I'll mention is that an offer letter, sometimes in an offer letter, we see there's some severance language, but it doesn't say they have to sign a release to get the severance, which means you have to pay them the severance and you don't get a release. So that's obviously a mistake. So make sure you have your legal counsel review any severance clauses in your offer letters or employment agreements that you have. Okay, well, I'm going to pause right there. That's my last slide, and maybe Brian will bounce a couple of questions off of me and then turn over to Brian.
Sure, so here's some questions, Ray. The first one is, if a California employer is months late in paying workers and then goes out of business, but it offers a $1,000 payment in return for signing a severance agreement, can these employees still file a wage claim for earned wages and late payment waiting time penalties?
Yeah, they absolutely could. And this goes back to California Labor Code section 206.5. The agreement, even if they sign it, would be void because they didn't receive their earned wages. And it would be one of those criminal law violations, even asking them to do that. I guess the other thing I'll just throw in there real quick as well is that there's personal liability. That's one reason why for wage claims, for many wage claims, there's even personal liability in case the company does go bankrupt. The employees can go after the officers and directors.
Okay, the next question is, does the NLRB's decision affect non-disparagement and release claims that are unrelated to acts arising out of the NLRA?
Yes, that's really clear. And sometimes people think NLRA only applies to, let's say, union-related situations, and that's not correct. I mean, some of the NLRA is focused on unionization and things like that, but this Section 7 of the NLRA, this McLaren decision is based on, applies to all employers, regardless of whether there's any union involvement.
All right, and one more question here. How often do you recommend that employers review their severance agreement templates?
That's a good question. So, typically, not only severance agreements, but employee handbooks and other important forms. So typically employment laws, change, let's say maybe once a year. And in California, we're used to getting a bunch of new laws passed in September that take effect on January 1. So I think annual is good, and maybe the perfect place to time it might be also the perfect place to time employee handbook review, which would be, let's say after September. If you haven't had these things reviewed in a while, though, I would say, do it right away, basically.
Okay. All right. Thanks, Ray.
Okay, great. Let's see. Do you have the presenter control now, or do I need to switch that over to you?
I should be good here.
Okay, sounds good.
Okay, so now that Ray has covered some really good general recommendations with respect to severance agreements, let's do a deeper dive into some specific federal and California law requirements for these agreements. So the first one is the OWBPA, the Older Worker Benefits Protection Act requirements for employees age 40 and over for individual terminations. Now, the OWBPA is an extension of the Federal Age Discrimination in Employment Act, the ADEA, sorry for all the acronyms, and this applies to companies of at least 20 employees. Now, just because this law only applies to companies of at least 20 employees doesn't mean that smaller employers can discriminate based on age. In California, you still have to be aware of the Fair Employment and Housing Act, which applies to employers of at least 5 employees, but the provisions here for the OWBPA, these apply to employers of at least 20 employees. So the first one, for individual terminations, employees age 40 and over, a severance agreement that seeks a release of age discrimination claims has to provide the employee with at least 21 days to consider the agreement. This time period can be voluntarily waived. Let's say the employee decides they want to sign it after 7 days without being coerced or pushed or anything like that. That's okay. They can shorten the time period and sign it sooner. But then they also receive 7 days to revoke their agreement to the severance agreement, and that cannot be waived. So it's important when you're working with employees or former employees age 40 and over that you not pay their severance until at least the 8th day after they've signed the agreement at the earliest. And when we talk about these number of days, the 21 and the 7, we're talking about calendar days. So hold the payment until at least the 8th day after the employee has signed the agreement. That time period is not revocable. And then finally, there also has to be language in the agreement that advises the employee to consult with an attorney. Now, there's also separate special OWBPA requirements for group termination programs. And a group termination program, essentially, it exists when an employer offers additional consideration for the signing of a waiver pursuant to an exit incentive or some other employment termination like a layoff or a RIF, and it offers these to 2 or more employees. Now, ordinarily, this would be some sort of standardized package of benefits pursuant to some formula. If you have like a one-off employee in a layoff where non-standardized benefits are being offered, speak with counsel about that as to whether they should be included as well. It kind of has to be looked at on a case-by-case basis. Now, when it comes to these group termination programs, employees get 45 days, employees age 40 and over. Again, this is also applicable to employees age 40 and over. Employees age 40 and over get 45 days to consider the severance agreement. And as with the 21-day period, they can shorten it if they voluntarily choose to do so, but you don't want to encourage it. You don't want there to be any sort of sign that their agreement or that their signature to it is coerced. So you just give them the 45 days and leave them be to sign it sometime within that period. And again, they'll also have the 7-day revocation period. Now, along with the 45 days to consider, the employer also has to provide employees an information table concerning the positions that are considered for layoff. And that we've provided at attachment D, and I just want to put it on the screen briefly just to make sure we're all on the same page. I won't go through this in nitty-gritty detail, but when I talk about an information table, this is the table that's going to include the criteria for selection, the amount of severance that was offered, and most importantly, the table of positions, not names, but positions, their ages, and whether or not their position was eliminated. Sometimes I have clients tell me that, you know, looking at this, it's going to invade employees' privacy because it's going to be clear who is in each position and their age and whether or not they're being laid off and so forth. But in this case, the federal statute requiring that you provide this to employees age 40 and over who are being terminated would take precedence over any sort of privacy concern. So the information table, it's going to include the eligibility criteria for release benefits and the time limitations imposed on the release benefits. That is to say, the 45 days plus the 7-day revocation period. Now, this is a form that you would update on a rolling basis. So where you're doing sort of layoffs on a rolling basis, you don't have to go back to people who have already been let go, but employees who are now being let go get an updated list of people who have been laid off over the course of the entire program. So someone who may have been laid off a week ago with the same severance offer is going to have a yes marked next to their name, and they're still going to be on this table that the person who's laid off today gets. Also, sometimes employers tend to think that, oh, maybe we can altogether get out of this requirement by just doing a series of continuous one-off terminations. But where these are all part of the same program, a court would say that's just a subterfuge to get around this whole requirement. And so even if you're doing one-off updates or one-off rolling layoffs, that's not going to allow you to escape this 45-day requirement along with the information table. Now, if it changed to an entirely new program, let's say you have a different set of severance benefits and this next round of layoffs is being driven by something different, perhaps the company lost a major customer, then you may be able to restart the table. But this is something that really needs to be, there's no generalizing this. This needs to be analyzed on a case-by-case basis. It's not like WARN where you have a bright line rule that after X number of days we can restart this table. It's generally on a rolling basis where it's pursuant to the same program. So again, where you have something like that happening, you know, it's important that you would want to speak with counsel about that. Okay, and we've kind of created these visuals. Actually, I'll give Ray credit. He's the one who created these visuals originally, but they essentially put into, for those of you who learn better through visuals, they essentially put into a visual specifically what I was just talking about with respect to group terminations. Now, one thing to call out on this that Ray mentioned earlier, you'll see with the termination date, the box there says the employer should not provide the release agreement until the actual termination date. So just to reiterate what Ray had mentioned earlier, because wrongful termination claim in California doesn't accrue until the last day of employment. And then Ray had also discussed other prohibitions on this. You can provide a draft before the last day of employment, but a couple of things to note about that. One is that the draft should be stamped draft all over, and it should be made clear that the employee cannot sign on the signature line. And then number two, just because you provide a draft before the last day of employment, that does not start the 45-day period running. The 45-day period does not start running until the employee receives the final version on or after their termination date that they are to sign. So sometimes I have clients who try to slip that draft in really early so that we can get the 45-day period rolling. That is a non-starter. That 45-day period does not start counting until the actual termination date, when the employee receives the release or the severance agreement. And here's the timeline for group terminations under age 40. You'll see for this one, between the termination date and when the time to consider expires, we have that the employee gets at least 5 business days to consider the agreement. That's for employees under age 40 in California. And I should also say that's not only for group terminations, that's for any separation agreement for employees under age 40 in California. That's a relatively new development that I'll talk about in a moment. Okay, so for special California legal requirements, a lot of these are driven by Senate Bill 331, which went into effect January 1 of last year, so January 1 of 2022. But you know, they also address some of the same provisions that the McLaren Macomb decision addressed, starting with confidentiality. Settlement agreements cannot prevent or restrict disclosure of factual information related to a claim in a civil action or a complaint in an administrative action regarding sexual assault, sexual harassment, workplace harassment or discrimination, or the failure to prevent harassment or discrimination, or retaliation. So that's a number of things that they cannot restrict the disclosure of. As far as non-disparagement agreements, the Senate bill on this one is pretty straightforward and easy. It just gives you language that you need to include in your non-disparagement agreement. Nothing in this agreement prevents you from discussing or disclosing information about unlawful acts in the workplace, such as harassment or discrimination, or any other conduct that you have reason to believe is unlawful. Now, it says it needs to be provided in substantially this form, but since it's given you a form of language or a form of clause to use, you may as well use it verbatim. So that's the language that needs to go into non-disparagement agreements. And then finally, what I mentioned is this minimum review period for all employees, regardless of what your age is. Number one, you have to advise the employee of the right to consult counsel. So for employees age 40 and over, that's already going to be built in as a result of the OWBPA requirements. And you have to provide at least 5 business days to review. And the employee can waive this period, like with the employees over age 40, they can waive this period as long as it's not coerced. So they get 5 business days to review. Now, unlike with federal law, this applies to employees under age 40 and then also to employers with 5 to 19 employees. This is kind of below the ADEA threshold I talked about, which is 20 employees, but above the FEHA threshold, the Fair Employment and Housing Act threshold in California, which is 5 employees. So it covers basically everyone, and there's no revocation period for this after the 5 business day period. Then for employees under age 40, the agreement becomes final. Other special legal requirements in California, the Section 1542 waiver, Ray mentioned this in passing, but the effect of this is basically to ensure that an employee is releasing unknown, so not future claims. You can't release future claims, but they're releasing unknown claims. Without this waiver, an employee can just say, oh, I wasn't aware of a claim. It was unknown. That had already arisen when I signed it, and so I can still sue you for it. So you need to be sure in California this Section 1542 waiver is built in. And by the way, for those of you who have not had your severance agreements reviewed recently, the language of 1542 did change a few years back. So you want to be sure you have updated language in your agreement. And then payment of final wages. This was another element that Ray mentioned is important to have in the severance agreement. This essentially confirms that the employee has received their final wages. Now, in California, the wages have to be received on the separation date, unless the employee provided less than 72 hours notice of resignation. But again, in resignation scenarios, most of the time, you're not going to be offering a separation agreement anyway. Okay, and then moving outside of California, some state law differences. And these are just a few examples. When you're doing severance agreements for out of California, you really need to be sure that your counsel has taken a look at any particular state law requirements. But these are just some that jump out. In New York, they have a general obligations law that prohibits an employer from preventing the disclosure of underlying facts and circumstances where a claim involves discrimination unless the condition is the complainant's preference. In that case, the complainant would receive 21 days to consider the agreement and 7 days to revoke, regardless of their age. It's the same as the OWBPA one-off termination requirement, but this one is regardless of their age. And there also has to be a carve-out on confidentiality to allow the employee to disclose factual information related to future claims of discrimination. Illinois also has a Workplace Transparency Act, kind of based on similar themes, but for this one, there's numerous conditions where confidentiality in a severance agreement is related to alleged unlawful employment practices where you're requiring that confidentiality. It has to be the documented preference of the employee. The employee has to be advised of their right to have the attorney review. There has to be valid consideration, no waiver of future claims, and again, 21 days to review and 7 days to revoke, regardless of age. And you cannot have a unilateral clause prohibiting an employee from making truthful statements regarding unlawful employment practices. Minnesota also has one. Employees have to be given in the severance agreement notification of 15 days to rescind, except for settlement of claims filed with the Department of Human Rights, an administrative agency, or a court. And then the rescission has to be in writing and delivered by hand, electronically with the receiving party's consent, or by mail. So the employee needs to be notified of all of those provisions. Other potential non-California state law differences. And by the way, just for the, in an abundance of caution, to be clear, when I talk about these non-California state law differences, it's based on where the employee resides and works. And, nowadays with employees, many employers going remote, they have employees all over the country. So it is not based on where your headquarters are in California. It's based on where the employee resides and works. So with respect to final paycheck, in some states, you may not need to provide these on the final day of employment. And then the waiver of claims, when you have that litany of laws that the employee is waiving the right to bring a claim under in California, we reference the Fair Employment and Housing Act. But in other states, you would change that reference to include specific reference to the state where the employee is. You also want to take a look at non-disparagement and confidentiality clauses in the laws governing those in the particular state. We have McLaren Macomb, we have California's laws, but this has really, even before McLaren Macomb, become a hot button topic in other states, particularly where there's been a harassment, discrimination, or retaliation claim. There are a number of states with restrictions on what you can and cannot have in non-disparagement and confidentiality clauses. And then there's also, in the severance agreement, a reference to the rules of evidence, where we're trying to avoid an inference that offering a severance agreement is an admission of liability. So you want to be sure that you've cited to the specific state rule of evidence for where the employee is located. Okay, so with that, let me stop and ask Ray if there are any questions on those slides that I just covered.
Yes, Brian, we have some good questions here. By the way, I just want to say good job, as always, on being so efficient after I, talk for so long. So good job catching us up there on the time. Let's see. Going to OWBPA, one of our favorite acronyms. How is so the group layoff, the group termination program? Could you again kind of cover what is a group? Like how many people is a group?
Sure. So a group is a group. I mean, the real straightforward answer to that question is a group is simply 2 or more employees. And even if, if one of the employees is under age 40 and one is over age 40, if one of the employees is laid off today, one of the employees is laid off tomorrow, but they're given the same standardized set of severance benefits, any of those variations. But once you have more employees.
Okay, great. I think your audio cut out there, Brian, at the very last part of that. But could you say something just to? Okay, then we may be having. Oh, go ahead there. It's a little choppy, but if you, maybe just reiterate that last sentence you said.
Sure. So any situation where 2 or more employees are being offered a standardized set of severance benefits, that would qualify for a group.
Right. And you also noted you were cutting out, but I could kind of hear what you said, that that's true even if one is on one day and one is on another day, and that's true even if one is under 40, one is over 40. That still adds up to 2, which you basically answered three questions that had been asked all at once. So okay, great. Well, we're at the end of our time, and I just want to say thanks to everybody for attending, and thanks to Brian for presenting with me. And we will stay logged in maybe 5 or 10 more minutes to try to type in some more answers to the written questions. If any of y'all want to hang around, stay logged in for 5 or 10 more minutes, we will do our best. And we'll look forward to seeing you on a future program. We do the next programs we have, you could see on our website, we have an Employment Law 101 training for your supervisors on managing hourly, i.e. non-exempt employees, if you're interested in that. And then probably our next program after that is going to be a mid-year California employment law update, which I'm going to guess is going to be probably in sometime in June or July. Thanks again for attending. We look forward to seeing you on the next program.